Okay, we're about ready to get started, and Sue is going to come up, and I'll turn the time over to her.
A few more people may trickle in, but we're going to go ahead and get started. I'm very pleased today to welcome our two speakers who will be discussing the Limited License Legal Technician program here in Washington. We first have Jean McElroy. Jean graduated from the University of Washington School of Law in 1983 and was admitted to the bar that same year. After working in the King County Prosecuting Attorney's Office for 5 years, excuse me, Jean began working at the Washington State Bar Association in 1989. Excuse me. In the Office of Disciplinary Counsel as Disciplinary Counsel. She's now Chief Regulatory Counsel at the WSBA, in which she manages and oversees bar admissions, licensing, and continuing legal education. Judge Paul Bastine, who does not prefer to be called that, he would prefer Paul, graduated from Gonzaga University Law School in 1964, served in the Peace Corps for 2 years before returning to Spokane to work as a deputy prosecuting attorney in that city. He served as presiding judge for the Spokane County Superior Court in 1998 and became the first family law judge in 1999. And served in that capacity off and on through 2005 when he retired from full-time judicial work. He served as a pro tem judge until 2010 and now serves as a private trial judge and mediator. He is most particularly involved with access to justice efforts, having held various appointments with the Legal Foundation of Washington, the Spokane County Bar Association, the Practice of Law Board, and Teen Child. In 2011, he was elected to the Board of Governors of the Washington State Bar, and he has received numerous awards, including the 2004 Judge of the Year Award and the Distinguished Judicial Services Award from Gonzaga University in 2005. If you would please help me in welcoming our two speakers. Thank you.
Thank you very much for inviting us to speak with you today. Washington State is very lucky and very excited to have the LLT program, which is really the first program of its type in the United States. Although I have to say that Washington State has had a limited license to practice law for approximately 30 years. We do have limited practice officers who are permitted to select, prepare, and complete documents to close real estate transactions. So in essence, although we bill this as the first, this is actually a second limited license to practice law in Washington. But it is a different path and a different road that these folks travel. Just want to say up front that we really appreciate questions and strongly encourage you to ask as we're going through, because I think it'll make the presentation more interesting, and I like to address those questions as they come up. So now I'm going to let Paul start, because in addition to being very knowledgeable about this, Paul was actually involved in the development of this idea and the rule from the very beginning. So he's very knowledgeable and experienced in this area.
It is an exciting opportunity for me to be able to talk to you. It may sound strange at my age to say that this is exciting. Generally, exciting for me means dealing with my grandchildren, contemplating a cruise in some warm climate, or dealing with nice homemade meatloaf. But the fact of the matter is that, as Jean said, I have been involved with this now for, I guess it's probably close to 14 years. And I'm going to give you just a little history. About 20 years ago, the state of Washington, along with a number of other states, began investigating the issue of how do you define the practice of law and what is the practice of law. And you all are certainly familiar with the fact that over the years there has been an increasing opportunity for non-lawyers to engage in what technically would be called the the issue of practice of law. For example, probably about 30 years ago, the Washington State Supreme Court had a case called Cultum versus Heritage House, in which the Supreme Court was called upon to determine whether or not the completion of earnest money agreements or buy-sell agreements by real estate agents was in fact the practice of law. Well, a careful analysis caused a yes vote with regard to that. So very simply, filling out that kind of an agreement, which is filling in the blanks on the legal form, choosing a proper legal form, constitutes the practice of law, and the Supreme Court found that to be the case. It happens all the time. You go to the hospital, you get a directive. The hospital is in effect, or whoever gives you that directive is in effect doing some things like the practice of law. So as we began trying to define the practice of law, the ground rules sort of became, how do you provide ethical, competent legal services to the public? How do you protect the public from the unauthorized practice of law? And yet, how do you not unreasonably restrain trade? And indeed, in Cultum, for example, the Supreme Court said, no, it's obvious we can't stop real estate agents from filling out blanks, and the other examples, and you can think of many of them yourself. So in 2001, General Rule 25 was adopted, which established the Practice of Law Board. And I was fortunate enough to be able to serve as vice chair of that board for 7 years, starting in 2001. And the Supreme Court delegated to that board the authorization to investigate allegations of the unauthorized practice of law, which in the state of Washington is a misdemeanor. And so it is a crime to engage in such activity. The Practice of Law Board was also authorized to issue advisory opinions regarding areas where non-lawyers could engage in performing legal services. And the examples I gave you, I think, are two of the ones that are pretty obvious. The third authorization was to make recommendations to the Supreme Court regarding how non-lawyers could engage in certain defined activities that would otherwise constitute the practice of law. Well, after a relatively short period of time, our board, which I'll get to in a minute in a later slide, came to the determination that we really needed to be able to have some kind of a way to assist the public far beyond these individual cited cases or whatever. So as a part of what the background, or a part of the background, was that in 2003, our Supreme Court had authorized a civil needs study. And the civil needs study showed, it was one of the first in the country, but it showed that about 85% of low-income people at 125% of the poverty level, that about 85% of them did not receive appropriate legal services when they needed them. It was not surprising that it was found that some of the areas that were of greatest need were for moderate income and low income people were in the areas of housing, family law, and consumer needs. Based upon that study, then we began with the directive from the Supreme Court to draft a proposal which we called the Legal Technician Rule. And in 2005, the Practice of Law Board had put together a general package with regard to this and proposed that we move ahead with such a proposal, in fact, licensing non-attorneys in some fashion in certain areas as long as they were properly trained. Well, I can tell you that I still have scars. People who took a look at this were not, well, let me back up. I shouldn't be as general as saying people. There were certain vested interests that felt their livelihood might be threatened by this. And as a matter of fact, the Board of Governors, which is the operating body that directs the Bar Association under the auspices of the state Supreme Court. In March 2006, the Board of Governors, who was funding the Practice of Law Board, decided they didn't like what we were doing and voted that we should not proceed. They didn't do it quite that way, but it was obvious that they were not happy with what we were proposing. But we went out, and we, being the Practice of Law Board, we felt we had the backing of the state Supreme Court. We went out and we talked to various interest groups, stakeholders all around the state, and we proceeded to put together this package. In the process, we investigated what areas of practice of law might lend itself appropriately to the legal technician rule. We set up 4 committees to investigate the areas that we felt might be appropriate. The first was immigration. Well, you may know that there are some non-lawyer activities authorized under federal law in the area of immigration. And it was felt after some investigation that immigration itself is not only a complicated area, but in fact, it probably was not an area where there was likelihood for someone to be able to make a livelihood or to proceed appropriately. Landlord-tenant was investigated, and indeed the subcommittee on that area came to the conclusion that this might be an appropriate area. Elder law, likewise. Some investigation indicated that this might be an area in which it would make sense to proceed. But family law, based on the civil legal needs study, based upon what we knew was happening in courts, what we knew was happening generally with low-income and moderate-income people, was viewed as the most likely area in which we might proceed. So in January of 2008, we, being the Practice of Law Board, reported to the Supreme Court on the proposed rule. And we recommended that the initial area be family law. Now in the state of Washington, and I think this may be true in most other states, we have uniform forms that are required in family law matters. And so to some extent it was based upon the needs, based upon the ability to use family law forms, based upon things like self-help books that were out there in the atmosphere. It was determined that family law was a logical area to proceed. So in January 2009, the Supreme Court published our first proposed rule with regard to proceeding with a legal technician process.
So you might notice on the slide that there's about a 3-year time period there. And you might wonder what was going on during that time. Well, there were several things going on. I mean, as you've heard, this was a real challenge for the Washington State Bar and for the members, and yet it was something that appeared to be very seriously needed. Nobody can question the need for access to justice resources being made available to people, and part of what was going on during this time was lawyers in this state were saying, well, give us a chance, let us try to meet these needs. And some of the things that were happening were there was a young lawyers committee out of Spokane area who was proposing a program that was designed to take young lawyers and use them to meet some of these needs. Additionally, the State Bar Association was attempting to set up and get running a moderate means program, as we call it, which is a program that's specifically designed to help people who are in that 200 to 400% of the poverty level, in that range, provide them with legal services by combining lawyers who are willing to reduce their legal fees with a way to get access for the clients to those lawyers. So these things were going on at the same time. Progress was slow, and basically the court eventually concluded that it was insufficient. The other thing that was going on was at a certain point, it became pretty clear to the staff at the Bar Association that it was likely that this rule was going to be adopted. It was likely that we were going to be asked to administer this program. And so we had to sit down and look at the rule as written and say, is this something that we could actually administer? And so at that point, I got involved and my staff got involved, and we actually had to look at it from the viewpoint of, okay, what does it say about what's required to be licensed? And how do you get admitted? And what are the tests going to be like? And what's the educational requirement? And, what do you do every year after that? Is there going to be a continuing education requirement? All of these things that go into essentially licensing lawyers were questions that had to be considered for licensing this new type of legal professional. And so we set about trying to come up with a scheme, at least a basic framework, where we could actually administer this new legal professional program. And so drafted some proposed amendments to the rule and sent those to the court, and they eventually were adopted. Now, does that mean that those rules were perfect? By far they are not, and we're not, and we are in the process of amending them regularly as we come across new issues that come up. But it was a place to start and a framework to start with, and that was what was needed to get this going.
As a part of that, you'll notice from the slide, the name was changed from what we started with as just simply legal technicians to limited licensed legal technicians. And I think the purpose there was to alert the public that this is a limited license. And these legal technicians do not have the authority to engage in the full practice of law. Just as an aside, once the area of family law was chosen, the sides were chosen also. And I can assure you that family law attorneys in the state of Washington did not embrace this rule unanimously. There were some who accepted it, but by and large, there was an area of discomfort from their perspective.
So in June of 2012, the Washington Supreme Court issued an order adopting the rule, and if you have never read this order by the Supreme Court, I strongly commend it to you. It is a pretty thorough description of the state of access to justice resources in Washington, about the needs, the legal needs that poor and moderate income people face. It was a pretty good summary of our legal needs study that had been done, and it makes some pretty compelling reasons reading, and it gives some excellent reasons for why this rule was adopted. You have to remember, of course, that our Supreme Court justices are all lawyers as well, and so, for everybody involved, this is sort of okay, wake up. Doctors went through this. They have physician's assistants and nurses, licensed nurses practitioners, and they have all sorts of, other levels of medical professionals. And so it's sort of a question of, get your brain around the fact that there is not just one brand of legal professionals. There are now, and there are going to be several types of legal professionals, and that's what the court is essentially saying. The major goals, and it's important also to remember that this rule came in essentially on these two tracks, side by side. One is access to justice, making sure people have access to affordable legal help, and that there's sufficient resources available. And the second rail of this approach is we wanted people to be competent and capable practitioners. So we like to summarize it as it was important to have this program be one that was affordable, accessible to a number of people, and academically rigorous. And so those were the guidelines that we were striving to achieve with the development of this rule.
The Supreme Court delegated the institution of this rule to a new board called a Limited License Legal Technician Board. We, as you've already probably observed, we call it the Triple LT for simplicity. It's not particularly an acronym that we love, but it's a lot easier than trying to tangle your tongue around a bunch of L's. The board is composed of 13 people appointed by the Supreme Court as an independent entity, operating out of the Bar Association and staffed by and funded by the Bar Association. The members of the board are lawyers for the most part, but includes 4 non-lawyers, including a legal educator who may or may not be a lawyer. The board was delegated to create and draft the operational details, and as Jean has indicated, the first big decisions were what would be the practice area and what would be the educational requirements. Now keep in mind that up to this point, everything that had been done was simply in the proposal arena, so that the work that the Practice of Law Board that I was engaged in had simply been to send a proposal to the state Supreme Court and ask them for their imprimatur, the authorization to proceed to put in place this mini bar association, if you will. And to a large extent, that's where many of the lawyers in the state looked, how many of the lawyers in the state looked at it then, many of them still do. Just as an aside, the funding for this comes from the Washington State Bar Association, which is funded by license fees from lawyers. So you can imagine, if you're opposed to the rule, kind of the push-pull effect that has. Now, the rule does require that at some point, I think still indeterminate, that this program must be self-funding. And based upon what happened previously in the real estate closing area, where we have non-lawyers who are authorized and engaged in that program, interestingly enough, that program, which has now been in existence for 30 years, is it, Gene? That program makes money, and makes money for the Bar Association. So the theory is, the hope is, that somewhere down the road, before too long, we're going to be in the same situation with the triple LTs. The initial practice area, as I've already indicated to you, proposed by the Practice of Law Board and ultimately adopted by the Supreme Court, is in the family law arena. The court approved that in March of 2013. And since that time, the Practice of Law, the Triple LT Board has moved forward. The board was appointed and has moved forward to put together the necessary framework to proceed in that particular arena.
So as you can see, the Triple LT Board has a lot of work before it, and one of the ways they're tackling that work is by dividing themselves up into these subcommittees. And if you look at the subcommittees that are listed on this slide, it might sound to you a lot like any state bar association or bar association in a state where they have regulatory functions. With the exception that the first thing that the Triple LT Board had to do is decide, okay, what are the limitations on this program? We're calling this a limited license. What are we limiting them to? What is the scope of the practice that can be engaged in? You have to remember, these people are not required to go to law school. They are not required to even have a bachelor's degree, but they do undergo very specific and rigorous education just specifically within family law. But there are going to be questions that come up that are just beyond the scope of what the triple LTs can handle. So that was one of the first things, is deciding what is the scope of this? What are we going to say they can do? Admissions and licensing, so what kind of education is going to be required? And what kind of a test? And who's going to write that test? Because the test does not exist. Even as we speak today, the test does not exist. So we're still working on that piece. The RPCs and some other descriptive functions of the Triple LT board, the rules of professional conduct for Triple LTs were considered to be, that was considered to be a vital piece of this licensing process. Because remember, part of the requirements for this program is we wanted to have competent and professional legal professionals who could actually help people and not hurt them. So protection of the public was very important. And so those rules have now been drafted and they have been sent to our state Supreme Court. So they are currently pending. They have not, I think, been published yet for comment, but they will be soon. And they're moving along. What the Triple LT board decided to do is start with the lawyer RPCs, rules of professional conduct, and run through each and every one of them based on the scope that had been set for the Triple LTs and discuss, does this apply to a Triple LT? Do the Triple LTs need to comply with these same duties? And that's a pretty arduous process. So what are some of the things that legal technicians can do or that they are required to have in order to be licensed? So they have to be at least 18 years of age. They have to have a minimum associate degree, level degree. They have to meet education, examination, and experience requirements. So one of the things I think you should have received a handout, which is called the Pathway to Triple LT Admissions. And that shows you what the educational requirements are, and we can go into those a little bit in more detail later on. But there are very specific paralegal educational requirements that are required, a certain number of credits and certain topics, and they all have to be completed. In addition to that, they have to finish 15 credits of law school level educational program in family law, and have partnered with the Washington State Law Schools, and particularly the University of Washington has been very helpful in this program. They are the housing for the program and take care of most of the details. So the Triple LTs have to go and finish this program, which is taught by law school combination. Each quarter is supposed to be taught by a law school professor in combination with an actual practitioner in the area of family law. And the reason for that is that we want these legal practitioners to have the ability to go out and actually handle people's problems day one on the street with their license in hand. They can actually go and do some of the things that probably even licensed lawyers might not be able to do very well straight out of law school. So that is the goal. Practical education along with theoretical legal education, possible because it's in a limited area. We also established that in order to qualify for admission, they have to pass a core education program, core education exam. And we opted to go with a national level paralegal licensing program. And so the exam that is currently being used is the NFPA Paralegal Core Competency Program. That's a baseline for being able to go on and take the other exams. Beyond that, we've now decided that they will need to take a professional responsibility exam, and they will have to take a practice area exam. And you'll notice we say a practice area exam because our expectation is that there will be more practice areas that will be licensed in the future. So the practice area exam will include multiple choice questions, essay questions, and practice exercise questions where they're given a library of information and they have to perform an actual function that they would have to perform out in the real world serving a client. In addition to that, they have to have 3,000 hours of substantive law-related experience. So they have an experience requirement, which again is not something that lawyers coming straight out of law school in most states are currently required to have. Because going into this program, there weren't going to be any people who were qualified in this way to be licensed. They did develop a way that currently licensed, very experienced paralegals could get qualified to take these exams and get licensed. And that's our limited time waiver, and that requires, having passed one of the professional licensing exams for paralegals and 10 years of substantive law-related experience supervised by a licensed lawyer. So it is actually a very practical, focused, and rigorous program. Yes, there's a question back.
Yeah, I'm just looking at the number of hours and adding that. They've got 45 hours of ABA education and then another 15 in family law. That's 2/3 of a law degree right there. So why would someone do this and not just go to law school?
Well, that's probably a very good question. The question is, looking at the number of credits that are required, 45 in the paralegal program and then 15 at the law school program, why would somebody choose to do this instead of becoming a lawyer? Well, it's going to be a lot less expensive, for one thing. We figure the total cost of all of the education in the one area is likely to end up at around $15,000 because the paralegal programs can be taken at the community college level. And so it will be a lot less expensive, and yet they will have a lot more experience and authority than a paralegal coming out of a paralegal program would have. So for those who might not think that they could afford law school, this would be a way for them to be involved in helping people with the legal system without having to actually complete an entire law school degree.
Well, and
Are those quarter credits like at the UW, not semester credits?
Yes.
So
and what you will find in a later slide is that the law schools, the 3 law schools, are teaching the family law component, but the other portion is being taught at community colleges all around the state.
Is that then excluding the paralegal program at the University of Washington? Because it's not an ABA accredited program?
So the
That's
question
correct.
is if that excludes the UW paralegal program, and the answer is yes, that's not an ABA accredited program. The answer is yes for now, actually. And that is a topic that's under discussion right now, is whether other paralegal programs can in some way establish, if they teach these credit requirements, can they establish that their graduates should be eligible for admission into this program?
And in fact, in Spokane, while it was an ABA accredited program, it didn't fit all of our requirements in some respects. So they have adjusted their curriculum and adjusted their program to make it compatible with the requirements of the LLT. And the expectation is that that will occur throughout the state. There's no reason why the programs can't be integrated and adopted, and the program here certainly is one that I would expect very shortly will happen. The law schools are very interested in this because, as you know, law school enrollments are down, and this burden that lawyers have when they come out of law school is just almost insurmountable in some instances, particularly at the private law schools. So there's great appeal from that perspective for non-lawyers and for the law schools and the educational facilities to engage in it.
One of the areas that I am in charge of is the admissions for lawyers, and I can tell you I regularly see applications for admission to our state bar where people have, easily $150,000. I've seen some with, $280,000, $300,000 in student loans to get admitted to practice law. And, to be really honest with you, in today's legal market and with the vast majority of the legal jobs out there, and if you really look at the salaries that most lawyers make, we're not talking about the ones at the very top end, which is a select few out of the graduates, they aren't probably going to pay those back for a really long time. Granted, if you're talking $280,000, $300,000, that's somebody who's borrowed money their entire educational career. That's probably not just law school, but still, it's a significant amount of debt.
But also keep in mind that in order to enter law school, you have to have a degree. So you have already completed 4, or in my kids' cases, 5 years before you ever get to that position where you can enter law school.
Right. So some other things that triple LTs are going to be required to do, they will have to show proof of financial responsibility, which lawyers are not currently required to do in Washington State. They will have to engage in continuing legal education at a smaller course level requirement than lawyers currently are. They will have to abide by a code of ethical conduct, and as you just heard, those rules are now pending before our state Supreme Court, and they have to be subject to discipline. So we are still in the process of attempting to develop the rules for the discipline system. That will be one of the next phases. As you can see, this was pretty much get this rule in place, then make the program work. And so that's what we're scrambling to do and trying to do as efficiently and effectively as we can. One of the big drawbacks that we found was trying to figure out how they would be able to establish their proof of financial responsibility. Our limited practice officers, who I already told you have a limited license to practice law in real estate closings, they have 2 ways of doing that. One is by being insured by their employer, and the other is by submitting an audited financial statement every year showing they have a net worth of over a certain amount of money. Really what we were interested in here was trying to find a professional liability insurance provider who would be willing to cover the triple LTs, and it took some convincing, but we think we actually have found a company now who is willing to do that, and so we're looking into that much more seriously now. So we're hoping to have that in place before we license the first triple LT, since it is a requirement. So what is it that legal technicians, the triple LTs, can do? Currently, under the way the rules currently written, in the scope of what they're permitted, they can inform clients about the procedures and course of legal proceedings. They can provide approved and lawyer-prepared self-help materials. They can review documents and exhibits from opposing party and explain them to the party they're working with. They can select, complete, file, and serve appropriate and approved lawyer-prepared forms and advise of their relevance. They can advise clients of necessary documents and explain their relevance, and they can assist clients in obtaining necessary documents. So one thing we didn't talk about is specifically what has been defined as the practice of law in Washington State. So it is the application of legal principles and judgment with regard to the circumstances or objectives of another entity or person which requires the knowledge and skill of a person trained in the law. That's General Rule 24 in Washington's court rules. It includes, but isn't limited to, giving advice about legal rights or the legal rights or responsibilities of others, selecting, completing, and drafting legal documents which affect the legal rights of another, representation of another entity or person in a court or in a formal administrative adjudicative proceeding, and negotiation of legal rights or responsibilities. So out of those 4 things that constitute, by definition, the practice of law in Washington State. Currently, legal technicians are permitted to do two. They can select and prepare complete those documents, and they can provide some advice to their clients about the legal process and what can happen. They can't appear in court, and they can't negotiate on behalf of their clients. However,
Go ahead. You're the one in the hot seat on that one.
those issues are currently being looked at. Is that a sufficient range of options? Is that a viable career path for somebody? Are they going to be able to make a living doing these things, or does there need to be more? Is it unfair to their clients to say, oh, I can only help you with completing these documents, but I can't actually help you out in court where you really need me and where the judges really need you and need me, because that would be too far. That's beyond the scope of my authority. And currently, what happens when they hit that phase is they either have to say, I just can't help you in court, or they have to say, I can't help you in court, you need to talk to a lawyer. And so that's the limit that's currently drawn. But you never know. Things might change, and that is something that's under review.
And there's some indication from the Supreme Court that they're willing to take a look at expanding into that arena.
So as we just talked about, there are limits on what they can do. These are the limits that we talked about. I don't know. Does anybody have any thoughts about that? Is that too restrictive? Do you think somebody could make a living if all they could do was, tell you these are the documents that we have, and I can help you complete these, but I can't help you out in court? Does anybody have any thoughts?
If you could use it to drive down the cost of an ordinary firm, so they could retain 2 or 3 paralegals, like your analogy to a practicing physician. But I think even in that market, you see that there is no reduction in cost. Actually, if you look at medical costs, they're about 70% a year, 17% 17 every year they've increased. So I'm not sure that you'd have savings, but that's the only way I think you could do it, that someone wouldn't get frustrated, especially in family law, where you can go anywhere from contract to taxation in one negotiation sessions. And I think it'd also be difficult because it's not uncommon for them to be facing a represented party that may have a lot more experience in the paralegal. So I don't know how you would get that kind of firm knowledge bank going with a paralegal unless they were affiliated first, because I don't think you have a critical mass of people that can pass that down. But it would depend on what the educational model was when they were teaching them to see how it would work. But that's the only way that I think that it would work in terms of family. And I don't know what the need is in, say, King County or in Washington in terms of the state. In Utah, where I'm from, the family law attorneys in our council, in our county, bill a higher rate than most attorneys. Their billers are around $250 an hour, when most contract attorneys are only making about $170, can bill at the same rate. So I think it'd really depend on the market on what they could produce. So
It's interesting that LegalZoom.com, for example, and you're probably all familiar with that, or some equally internet-based organization, can help people in this regard for about $250. And so you can look at that as a potential market, I would expect. It's also interesting to note that in this first class we have of 17 people, is it, Jean, at this point?
Well, they're currently, I think, 15. We're
15. A number of them are people who are working for law firms, and the law firm intends to keep them on, and in fact, theoretically, provide it at a competitive rate. It's hard to know. You make a good point.
Comment here.
Before coming to work in Oregon, I practiced for some period in Illinois, and Illinois at least has a large oversupply of lawyers. And a troubling aspect to me seems to me, and you raised this to yourself, that lawyers are are faced with high education costs and then and a poor job market, and so that it seems like providing limited persons who could provide limited legal advice is addressing a symptom of a problem that without addressing some of its core causes, the cost of legal education and so forth, and so presents to attorneys a difficulty that you're now going to provide education to people who will undercut you on cost at a time at which the market is so poor, and that you're still required to be licensed to take on all these debts. And so how do you address the concern, as I'm sure this has been raised not for the first time, how do you address that concern on the behalf of lawyers that if you segment the market like this, it will make it very difficult for them to repay those costs, and that I think the comparison with the medical profession is a little troubling because, of course, doctors have an undersupply and will continue to have an undersupply of doctors into the future. Why not instead focus on reducing the costs and offsetting the costs of providing full legal representation rather than segmenting the way in which people will provide representation?
Yes, we do hear that question regularly, and I think it's a valid point. I mean, how can we expect lawyers carrying a very significant debt load to be able to meet all the needs that are out there? There's absolutely no question that the need is there. Somewhere around 80% of the population appears to feel they have legal needs that aren't being met. And those are generally people who can't afford attorneys. And yet, how can we ask lawyers to charge a lower rate straight out of law school if they've thought to meet these requirements that they've thought? And so it's a very good point. But I think the answer has to come from, looking at the future. What is the future of the legal profession, and really trying to hone in on what is it that lawyers can do that others can't do? What is the unique skill set that we as lawyers bring to the profession, bring to the public, bring to the practice, and how do we identify that clearly enough that people who have legal needs will understand when they want to go to a lawyer? Because there's absolutely no way that a triple LT is going to be able to handle everybody's legal needs, or even in most cases all the legal needs of a particular client. And yet, how do we make that available and clear, and yet allow people to meet the unmet legal needs that are out there? Sort of the two prongs of why this rule was adopted by the Supreme Court. I think it's an excellent question, and I really, we routinely challenge our lawyers and around our state bar. The staff, we are constantly trying to think about and focus in on what is it that lawyers are needed to do? What are the legal skills? What are the ideas and the background and the training? What is it that we are uniquely trained to do? Or simply, what are we better at? And how do we inform the public about those kinds of things? And I think those are very valid questions.
Let me give you a personal anecdotal response. 30 years ago, when the limited practice officer rule with regard to real estate closings was enacted, my personal practice in Spokane, I had 6 paralegals working for me who did real estate closings, and I supervised those 6 paralegals. When the rule came into effect, it effectively wiped out that. And that income was about 60% of my income. The other 40% of my income was from my practice per se. After 2 years, and I no longer had any paralegals, my income had increased by 50% higher because I was doing real estate law, not paralegal stuff. And certainly it may not be totally equivalent, but that was my personal experience. And one of the things that caused me to believe that this rule probably makes some sense. One once the marketplace adjusts to it. I think you had a question?
Mine's kind of tied to the last question. What makes this preferable to unbundling?
Not necessarily anything.
Right. If we could just get lawyers to unbundle, you know, and if we could get, one of the things that I argued starting in 2008 when people were complaining about this, the family law bar, get out and do it. Hire a bunch of paralegals. You can supervise them. You can unbundle. You can do these kinds of things. There was reluctance, and there still is reluctance to do that. So they allow the marketplace to deal with it by things with like LegalZoom.com or the paralegal who advertises on Craigslist. If you go to Craigslist in any community, and I've done it, you find ads that say, you know, I am providing this kind of service, and those people are making money. They came into my courtroom and did a botched up job, but people were paying them to do it.
There's a question in back.
I just want to know if there, I realize that we're still very new, but have there been any statistics done on claims or any malpractice issues? What kinds of liability is required on the technician's part?
So we're actually further back from that in that we haven't even been able to license anybody yet. We have our first class finishing their law school requirement this quarter. So they're taking their third quarter of family law at the law school. We hope to offer the exam next March or April. And we hope to be able to license some of our people who are currently in the program by that time, by the conclusion of that. So by late spring, early summer of next year.
It is a concern.
So will there be, I mean, have there been discussions with how they're going to be insured, backed up, I mean, besides just getting licensed?
Right. The question is what will be the requirements for making sure they're insured or backed up in some way? And yes, they have to establish financial responsibility, and that means they will have to establish that they have professional liability insurance. We do believe that we have found a company that is willing to provide such an instrument to the legal technicians, and in fact, they seem quite excited by it. So we're hoping that they might see that the people who are in the LLT program will be coming out with not just the legal education, but also practical hands-on experience as well, both from their 3,000 hours of practice experience that's required and from the way the classes are being taught, which is to include this practical component.
My question was just related to that. In those 3 years, their 3,000 hours where they're supervised by a licensed attorney, are they running under the attorney's malpractice insurance during those 3 years?
I assume that the attorney, Washington doesn't require lawyers to carry malpractice insurance, but they would be working under the supervision of that lawyer. So the lawyer is responsible for the actions.
So I know we're getting close to 2:30. Maybe we should let them finish their presentation before we wind up.
So we talked about needing to define the scope of practice, and so these are the things that currently the LLTs will be able to do. Child support modification actions, dissolution and legal separation actions, domestic violence actions, committed intimate relationship actions, parenting and support actions, parenting plan modifications, paternity actions, and relocation actions.
Limitations will include not being able to divide up pension plans, businesses, real property issues, those kinds of things that might have significant dollar values. Those will have to go to an actual lawyer or be worked out in that kind of fashion.
So here are the admission requirements again. We've already talked about that, and this does not list the professional responsibility exam that will be required. This is a listing of the core education, the 45 hours that are required at the paralegal program. And so this did require several programs to modify the courses that they were teaching, either in the terms of the focus that they put on that course, meaning translating to credit hours, or in terms of offering like a 1 and a 2 in their classes. We will, as I said, we expect to be able to license several practice areas, and each practice area will have its own educational requirements, and all will have the core requirements, and then there will be additional educational requirements beyond that. We have a map here of where the different community colleges and law schools are that within this state. We're hoping to have a program that covers each area of the state. Talked a little bit about the limited time waiver requirements, and those are up there.
The law school curriculum taught by the 3 law schools is available online. So while it's live, it does not require you to come to the campus. You can do that from an appropriate online facility.
And then what is the LLT board working on? What were they working on in 2014 in some cases? They were working on the RPCs. Those have now been submitted to the court. They are working on the exam. We are actively writing the exam for the final family law piece. As I said, the core curriculum and the RPC piece. The core curriculum is tested through the national licensing exams. And then they're working on trying to define the next practice area. I think we're at the end of our time, and I thank you very much for your attention.